Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello again. In this and the next lecture, we're going to be covering the Voluntary Chapter 7 bankruptcy. That's a form of liquidation of debt case. The objectives, I've kind of shortened them up to some, unlike the last objective statements in the previous lectures, to sort of tidy this up a little bit. So there's a lot to cover, but that's why it's in two parts. So hope that it is manageable this time. All right, so preparing to file is what we're going to cover, what the forms are, the bankruptcy estate, how that's defined, exemptions to creditor claims, if you're wondering what that means, if you haven't explored that much yet, and the automatic stay. I'll explain what each of these are. So, Chapter 7 bankruptcy. Most of our bankruptcies in America, 75% in fact, as of the fiscal year 2024, were for individual debtors. And it's available to businesses. However, businesses rarely file it. Chapter 7 basically, for a corporation, provides no discharge of debt, but it does put the world on notice that the business is no longer operating. But again, generally speaking, individual debtors, human beings, file Chapter 7. There is a pre-filing requirement that was discussed in the last lecture. And within 180 days prior to filing a petition in bankruptcy, an individual must obtain a briefing from an approved nonprofit budget and credit counseling agency. And this agency helps to outline they outline the opportunities and assist the debtor in performing a budget analysis. This again was part of the BAP CPA, and that's why this citation to Title 11 USC is included. Debtor has to file the completion form from the agency. In filing the petition, on this note, their attorneys must give written notice to the individual debtor before the petition is filed. In other words, this form number 201A, Notice to Individual Consumer Debtor, or 201B, Certification of Notice to Individual Consumer Debtor, is set out again in Title 11, and it describes the services that they can receive from credit counseling services, describes the purposes, benefits, and costs of the 4 types of bankruptcy proceedings, and informs the debtor of bankruptcy crimes. The document that all debtors need to commence the case is the voluntary petition. And this is covered under Title 11 as well. There's an official form number B1 that applies to this. And the rules of bankruptcy procedure also explain this. So I've placed in this particular lecture, especially in the next one, this one and the next one, and I think the 2 others following, I've included these cites to the applicable rules and statutes, USCA. I'm doing this so that you will take a gander at the rules and statutes and see what you might make sure in the preparation for taking the exam you begin to study. So there's a couple of quizzes in the course, or at least one with some questions that'll maybe help you with your memory on that. So filing the, let me go back to that slide. I didn't really finish what I was saying. All right. The individual debtor also needs to file with the petition a statement of their Social Security number or individual taxpayer identification number. Remember that business will be eligible for Chapter 7, and they would have a taxpayer ID. And even an individual debtor who perhaps owns an LLC would have a taxpayer ID for that LLC. But as the owner, manager of the business, they would probably report both. I'm not sure what goes on that. Probably both would go on the petition and included in the statement. The statement of compliance with the credit counseling requirement is also required with the petition. So 180 days prior, within 180 days prior, they have to have the compliance of the credit counseling agency, and they also have to file a certificate. They get some proof from the agency that they include with this compliance form. All right. With that petition, if there's a business filing coming along with this petition, it would need a corporate resolution authorizing the filing of a Chapter 7 petition. They do that in their own format, and a corporate ownership statement. All debtors, no matter the chapter, file their names, address, and debtors. It's a matrix list of creditors. Basically, it's a matrix. There's debtor 1 with the name and address, debtor 2, or creditor 1, name and address, creditor 2. It's a big part of the paralegal's job to make sure these get prepared correctly and the matrix comes out right. And there's also a declaration required if there's a non-attorney bankruptcy petition preparer. All right. The filing of the petition. So with all debtors with the petition, that disclosure of bankruptcy petition preparer, if you're using a petition preparer, an attorney is not a bankruptcy petition preparer. The list of creditors that accompanies the petition, back to that matrix, if the list of creditors accompanies the petition, that matrix I was talking about on the previous slide, they have a few extra, they have 14 days extra to file their certification that notice to an individual debtor of primary consumer debts has been given before the petition was filed. That was the notice we talked about 3 slides ago. Certificate of credit counseling and debt repayment plan, just spoke about that. Statement of current monthly income means test calculation. So there are official forms for parts of this, specifically the certification and the monthly expense and means test calculation. The certificate of credit counseling and debt repayment is something they receive from the agency where they got their credit counseling, and then they would attach that to the form we just spoke of in the previous slide. All right. So the filing of the petition also requires, if the list is included, you have 14 days to copy all the payment advices or other evidence of payment received by the debtor from any employer within 60 days. So this is part of the means testing. We're talking about paycheck stubs. Or other evidence for a business would look a little differently. Statement that also included is a statement disclosing any reasonably anticipated increase in income or expenditures over the next 12-month period following the date of the filing of the petition, and that's a specialized official form. If the list of creditors is with the petition, these documents are filed within 14 days. Schedule of assets and liabilities, an official form. I think the name of that is clear. Schedule of executory contracts and expired leases. We covered that in one of the previous 3 lectures. An executory contract or unexpired lease is one of those, like a lease agreement or contracts that have not been completely satisfied. Schedule of current income, that's an official form, and schedule of current expenditures of individual debtors, and the statement of financial affairs, which is a snapshot of just about everything for the past few years. These schedules are scheduled A, B, C, D, E, F, etc. So that's something important to recognize about the schedules. Most of them have that official formness to them, so official forms have that structure. The statement that must be filed by all debtors represented by an attorney within 14 days of filing is the one disclosing compensation for the debtor. That's a procedural form number B203. I've also noticed that some authors that I referred to for information on this, they will 203B instead of B203, and I'm not really sure why, but they just do. It's maybe just a habit, maybe something old versus something new. I really don't know. I didn't go into my investigation that far, but just so you don't let that confuse you in the quizzing for this particular topic, whether it comes before the number, whether the letter comes before the number or after the number. But the statement disclosing compensation of the debtor's attorney is as simple as it sounds. It's like, this is how much I'm charging. I don't know if they attached the fee agreement to that. I can't remember. It's been a few years. But if it's optional, some lawyers might, some lawyers might not. If the schedules of assets and liabilities include debts secured by property of the estate or personal property subject to an unexpired lease, that's back to executory contracts and unexpired leases, an individual debtor, so we're not talking about corporations or business of any kind, has to file the debtor's statement of intention. So what the statement of intention does is basically tells what the intention of the debtor with regard to secured property. In Chapter 7, do they intend to keep paying on it? Do they plan on redeeming it? Do they plan on reaffirming it? That would be continuing to pay on it. And several other things. So they need to do this within 30 days or by the date set for the 341 meeting of creditors, whichever is earlier. If an individual debtor fails to file that information, they can be subject to dismissal. So it's definitely not a good idea to miss that, miss the forms. So these forms will basically list out these information required. So there are about 3 slides that cover this. I think there are 9 or 10 things. I know I'm pretty sure there are 15 official forms, and I prepared a chart for students. It's in the course where you can take a look at that list to guide you in your studying. And so the list of creditors needs to go with the petition if it can, or it should. Schedule of assets and liabilities, pretty much I've just discussed that. Schedule of current income and current expenditures. And also a statement of the debtor's financial affairs, certificate by the attorney that, or by the bankruptcy preparer who signed the petition under Title 11, that indicates they delivered that notice that they have to send to the debtor. They have to give the debtor that notice of the different types of bankruptcy available, that they are themselves a debt counseling agency, the firm is, or the lawyer is. But basically it's like, I did in fact give this notice, and this explains that it was done. Also included are payment advices. I mentioned this in a previous slide, documentation of employment income or business income. The net income, this is the schedule that shows how much income is made by the debtor or individual debtor or by the business, and disclosing any reasonably anticipated increase. Sorry about the repetition, but sometimes I apologize. I'm looking at a PowerPoint presentation and cobbling it together and don't always realize I have some duplicates. So my apologies for that. Moving on then. Not later than 7 days before the date first set for the meeting of creditors, the debtor must send to the case trustee and to any creditor who wants a copy of it the debtor's federal income tax return. And filing the petition also the certification of their instructional course concerning financial management. That's a debt counseling agency thing. Again, sorry for this little bit of repetition. So the process of the petition, they're filed with the clerk of the bankruptcy court. These days it's with the electronic filing system. And most bankruptcies, most of them are, I think all bankruptcy courts are probably using the electronic filing system. So what happens? The significance of filing a petition. Once a Chapter 7 by the debtor is filed, an estate is created. So it basically locks in what is this, does this estate look like? An estate is defined in the definitions of the code that I recommend you get used to reading. And the automatic stay will go into effect. The automatic stay says that there can be no further collection. And if there is, there can be some ramifications of the creditor that does that. And could be some fines or other types of problem stuff. And the interim Chapter 7 trustee gets appointed. So there's an interim trustee, and so be the case trustee. The estate includes all legal and equitable interests of the debtor as of the date of the filing. So, and there are some minor exceptions, some expectations, like a personal injury case with something outstanding, a potential settlement outstanding, or a potential award outstanding. The estate might not necessarily include that yet, but it could be a part of the estate later on. So I don't want to get too deep into that. But the debtor can claim certain property of the estate as exempt. So this meaning that these properties that fall within the exemptions would be unattachable by creditors if it falls within the exemption property and or property value amounts. So they're going to, so everything that's not exempt is part of the bankruptcy estate, and everything that is not exempt there may be things that are exempt, that the case trustee may decide to abandon, so that it's removed from the estate. The bankruptcy estate, everything else beyond the exemptions, beyond that which the trustee abandons, would be assets of the estate subject to administration for the benefit of creditors. And after the petition is filed, that property acquired after that time is not property of the estate, but there are some exceptions if they're acquired by certain means within 180 days of filing the petition. And we won't be going into that too deeply either. So more on the bankruptcy estate. In addition to the property that the debtor has an interest in at the time of the filing of the bankruptcy petition, these are those exceptions if acquired within 180 days of filing the petition. Property acquired by someone's bequest, devise, or inheritance. Property acquired as a result of a property settlement. I brought that up earlier. With the debtor's spouse, for example, a dissolution of marriage could bring a property settlement of maybe a dissolution pending or something, or of an interlocutory or final divorce decree. And property acquired as a beneficiary of life insurance policy or death benefit plan. So, I mean, back to that second bullet point, if you think about dissolution of marriage, that there could be a case pending and the need for filing bankruptcy comes about and before the case is completed. And so we don't know who has what. In some cases, property that looks separate, like i.e. it belongs to one spouse as their individual property versus both spouses. Those are legal quagmires that get worked out in the dissolution of marriage situation, and something may transform into the debtor's property. So life insurance benefits or death benefit plan acquisitions can also be subject to becoming a part of the bankruptcy estate. So all of this property now that's legally considered the bankruptcy estate is now under the exclusive jurisdiction of the bankruptcy court, the United States Bankruptcy Court, regardless of where the property is located. So it could be in Florida and you have property in Wyoming. That Wyoming property would be part of the estate. Exemptions. So this is essential to understand. The debtor may exempt certain property from the estate. There can be some specified property types or a specified dollar amount of the item. There are, let me see how we explain this. Exemptions can flow into state law too. So the Bankruptcy Code gives the debtor a choice between the state's exemptions and the federal non-bankruptcy exemptions, or the federal bankruptcy exemptions. So there are choices that the bankrupt person, the debtor, can take. That's what I was getting from that last comment. The Bankruptcy Code permits a state to opt out of giving the debtor a notice, so that limits the debtor to the debtor's state exemptions and the federal non-bankruptcy exemptions. 34 states have chosen to opt out, and the Bankruptcy Code doesn't speak to whether a debtor can convert non-exempt property to exempt property prior to filing a petition in bankruptcy. The automatic stay. The automatic stay is one of those things that the debtor is very interested in because it stops collection activity. No more efforts can be made. It stops foreclosure actions, at least temporarily, and it doesn't stop things in criminal court. Doesn't stop paternity cases or modifying domestic support obligations, spousal support. And it doesn't stop actions concerning child custody or visitation, or actions related to the enforcement of child support. So bankruptcy cannot be used as an effort to circumvent that. Okay, so reviewing this, we've already discussed all these points, but to sort of put it all in a capsulized format, 75% in 2024 were Chapter 7 individually filed bankruptcies. Credit counseling within 180 days before filing is required. Documents are submitted, including the voluntary petition, Social Security statement, credit counseling compliance, and schedules of assets and liabilities. That information is due within 45 days. If it's not in time, it is subject to court's dismissal. So the petition is what initiates the case and triggers the automatic stay. The counseling 180 days prior is essential. It's a pre-filing and notice requirement, and there's a formal procedure for the debtor's attorney to provide to the debtor as to describing the credit counseling services, bankruptcy types, and bankruptcy crimes. It's formalized as a procedural form. The voluntary petition initiates the case, and the corporations have to file a corporate resolution along with it and a corporate ownership statement.
The debtors file their names, all debtors file the names and addresses of their creditors, and if a bankruptcy petition preparer is involved, a declaration and disclosure of compensation. Schedules and statements are filed either with the petition or within 14 days. I would say from my experience, depending on the rush, we can get the petition in, but maybe not in the notice of Social Security number or whatever in. We're not always able to have every schedule ready. That there can be a dismissal without it. Other filing requirements, the individual certification of credit counseling. They do a means test calculation on an official form, payment advices, which is evidence of paycheck stubs and that sort of thing, or other forms of employment, I should say other forms of income, and federal income tax return needs to go in, and it goes to the trustee, and if a creditor requests it, they can ask for it as well. Avoiding these requests can result in a dismissal. And it's filed electronically with the bankruptcy court, and the clerk then commences the Chapter 7 case, and bankruptcy estate is officially created. The automatic stay is triggered, and the Chapter 7 trustee is appointed. And it constitutes the order for relief under Chapter 7. So this concludes Lecture 5. Thank you very much. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.